This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to talk about what happens when a plaintiff sits on his rights and why a victory against an insurer is not always available to a litigant. Many people and their lawyers believe that suing an insurance company that denies a claim is a guaranteed multi-million-dollar successful lawsuit. However, courts don't believe in such a certainty and require the litigants to promptly file their suit and allege facts that they can prove that supports their claims. In Azam Ahmed, individually and on behalf of all others similarly situated versus Cigna Health Management, the United States District Court for the Southern District of New York on July 8, 2024, applied the rule of law instead of the hoped-for certainty of always profiting from a suit against an insurer. Azam Ahmed claimed that the Defendants Wellfleet Insurance, Wellfleet New York Insurance Company, and CIGNA Management, Inc. refused to cover medically necessary procedures in contravention of his health insurance policy. Ahmed's breach of contract and insurance law claims came years too late, and his attempt to recharacterize his contract claim as one for fraud or unjust enrichment also failed. In August of 2016, Ahmed enrolled in New York University's student health insurance plan, and the plan was issued by what is now Wellfleet New York Insurance Company and administered by what is now Wellfleet Insurance. Years earlier, Ahmed had been diagnosed with a congenital birth defect resulting in skeletal abnormalities and symptoms like headaches and joint pain. He also suffered from facial asymmetry as well as issues with chewing, articulation, breathing, and jaw locking. He was a sick young man. In May of 2017, Ahmed had surgery to address his symptoms. His pre-authorization request was approved by Wellfleet via a third-party vendor that had been hired by Wellfleet to perform medical necessity reviews. The surgery, though partially successful, did not fully resolve his symptoms, and 7 months later, Ahmed's surgeons determined that a second surgery was necessary to further remedy his skeletal deformity and ongoing pain and breathing problems. Ahmed sent a pre-authorization request for the second surgery to Wellfleet, which was reviewed by CIGNA Management, Inc., who rejected the request since it seemed to be all just making him look better. Ahmed also alleged that Cigna was unjustly enriched by receiving from Wellfleet a portion of the insurance payments and premiums paid by Ahmed while intentionally and systematically denying coverage of medically necessary services and procedures in contravention of the insurance contract under which he was due benefits. Ahmed also sought to represent a class of others whose pre-authorization requests were denied. Wellfleet and Cigna moved to dismiss. Ahmed brings claims for breach of contract, violation of New York insurance law, fraud, and unjust enrichment. But the first two claims come too late, and Ahmed's factual allegations are a poor fit for the latter two. Ahmed sued Wellfleet for both breach of contract and violation of New York insurance law. Both claims were time-barred because Ahmed's contract claim imposes a 3-year time limit, meaning that Ahmed brought his suit 2 years too late. With regard to his fraud claims, just as with regard to the contract claims, Ahmed failed to plausibly allege fraudulent concealment. He had Wellfleet's reasons for the denial and the policy that serves as the basis for his claim, More than 3 years passed since all of that, and so, like Ahmed's contract claim, his statutory claim must be dismissed entirely as untimely. And his fraud claims also must be dismissed because a fraud claim will not lie if it arises out of the same facts as plaintiff's breach of contract claim. First, Ahmed fails to identify any duties that are separate from the duty of performance. Ahmed appears to argue that the special facts doctrine imposed a duty on the defendants to disclose their intention to breach the contract, but this argument fails for multiple reasons. To start, the doctrine usually applies in the context of business negotiations where parties are entering a contract, not in the case of a breach of contract. Second, even if it does, Ahmed does not identify any facts that defendants failed to disclose. His unjust enrichment claim also must be dismissed. Cigna argued that this claim must be dismissed because, among other reasons, it concerns the subject matter of a valid and enforceable contract, and the existence of a contract precludes Ahmed's unjust enrichment claim. Here, by contrast, the dispute derives from conduct in contravention of the insurance contract by a party that was acting as a subcontractor to the counterparty to the contract. The dispute arises from the actual breach of contract that Cigna allegedly facilitated. Ahmed's fraud claim is defective because intention to breach is not the kind of fact required to be disclosed under the special facts doctrine. In addition, Ahmed fails to allege that he had any relationship with Cigna prior to the denials, making it unclear whether the special fact doctrine even applies. Ahmed initially brought this case thinking that defendant used an algorithm to deny his pre-authorization request. His claims are either untimely or are a poor fit for the doctrine he tries to cram them into. As such, the defendant's motion to dismiss were granted with prejudice. Defendant's motion to strike the class allegations was denied as moot. In my opinion, waiting more than 3 years to sue was fatal to almost all of Ahmed's claims. His attempt to avoid the limitation of action by claiming fraud was perhaps imaginative, but unsuccessful because none of the elements of the tort of fraud applied, nor had he any ability to state evidence that he was the victim of a fraud. This video was adapted from my blog, Azam Insurance, which is available free to anyone who clicks on the URL zalma.com/blog. You can subscribe to the blog, and you'll receive notice of every blog posting, usually 5, sometimes 6 a week. And you'll also have access to the more than 4,800 blog postings. Please tell your friends and colleagues about the blog and the videos, and let them subscribe to the blog and the videos. They're all free as well. And if you're interested in more detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.